Good afternoon, everyone, and thank you for joining us. We appreciate the opportunity to present to you our presentation today, Understanding Homestead Exemptions and Personal Exemptions. My name is Kevin McKeon. I'm the Deputy of Assessment Administration with the Property Appraiser's Office, representing the Honorable Mike Twitty. Also with me today is Alex Luca, our Director of Exemptions and Staff Counsel, who will do part of the presentation as well. We will be covering a variety of topics related to homestead exemptions, Save Our Homes portability, also all personal exemptions. And we hope you get a lot out of this today. And we encourage you online, if you have any questions during the presentation, please type them in the chat and we will attempt to answer them as we go along. And also we'll have some time at the end for questions as well. So to get started, we'll jump in right into the homestead exemption. Just a little bit of the history of the homestead exemption in the state of Florida. It started back in 1934 at $5,000. It doubled to 10 and 60, and then in 25 it became, in 1980 it became 25,000. That was changed to 50,000 in 2008, where an additional $25,000 exemption was added. And also at that time, the concept of portability and the 10% cap was introduced on non-homestead property. Between then, in 92 to 95, there was a Save Our Homes amendment, which we'll get into, which basically caps the increase of your assessed value once you establish homestead, which is a huge benefit. And the now, beginning in 2025 and beyond, the second 25,000 homestead exemption is annually adjusted for CPI. So you will notice in your tax bills this year that the second 25,000 has gone up slightly by the CPI. Okay. So there are two homestead exemptions based on the property's assessed value. Like I said, the first 25, which was increased back in 1980, is on the first $25,000 of assessed value and applies to all millage rates. There is no exemption on the value between 25 and 50,000. And then the second exemption, it comes in between the value above 50,000. It used to be 50 to 75,000. However, as previously mentioned, starting this year, 2025 and forward, the second homestead exemption is indexed annually, which will go up by CPI. So it's 25,722. So it applies to all millages except for school. You will see there's only a $25,000 exemption for school millage. When they put in the additional exemption, they didn't want to affect the amount of taxes collected for school. And then above that cap of 75,722 this year, there is no exemption. So the first and second combined exemption, on average, depending on your taxing district that you live in within Pinellas County, save you about $500 to $1,000. Okay, but the Save Our Homes cap, which once you establish homestead, limits the annual increase of that assessed value to 3% or CPI, whichever is less. That is a very valuable quote unquote exemption that you're not paying taxes on that. If your market value rises, you're not paying taxes on that difference between market value and assessed value if you have homestead. And this year the CPI was 2.9%. Come on in, ma'am, have a seat. So the qualifying criteria for homestead is you must own and occupy a property as of a January 1st. So if you buy a property on January 10th, you will not be eligible to the following January 1st of the next year. You also must be a permanent Florida resident. Being a permanent Florida resident requires you to have a Florida driver's license and an automobile, if you have one, registered in the state of Florida. You can only have one homestead per person or marital unit. If you are married, you can only have one homestead. And you can have no other residency-based exemption in any other state or country. So I know our Canadian residents who have free healthcare in Canada, that is considered a residency-based exemption. So you are not eligible for homestead exemption in Florida unless you give up that benefit in Canada. And if you own a home in another state that has an exemption, you would have to remove it in order to qualify for homestead exemption in the state of Florida. And corporate ownerships do not qualify for a homestead, and that includes an LLC. So if you're considering for liability reasons moving your home into an LLC, be very careful. That LLC will not be eligible for homestead, and you could lose a very valuable exemption and save our homes cap. This should look familiar to some of you. If not today, tomorrow. We just mailed our homestead renewal notice. And it's in mailboxes. It's hitting mailboxes today here in Pinellas County. We do this on an annual basis to give you an opportunity to, first of all, let you know that all the exemptions you had in 2024 still exist in 2025. There may be some exemptions that you thought you had that are not listed on here. So in this particular one, to John and Jane Smith, they have homestead exemption and nothing else. If you believe, again, and there's a questionnaire down below, it gives you an opportunity to tell us whether you've moved, whether you've rented, whether you got married, whether you got divorced. And it's an important piece of information to let us know, because each one of those changes could affect your homestead exemption. And we want you to let us know so we can avoid possible future penalties in the future, or giving you more exemptions this year that you may be entitled to, such as the senior exemption, etc. Homesteaded owners can expect to receive it again today or tomorrow here in Pinellas County. We just mailed it, and I know it's in my mailbox at home. Another important piece of mailing that comes from our office comes out in August. It is the notice of proposed property taxes. We refer to it as the TRIM notice, which stands for Truth in Millage. Okay, this gives you the current values of your property for 2025. It will in 25 when it's mailed, as compared to 2024. And it also gives you the amount of exemptions that you have or may not have. And this gets mailed in mid to late August. And you still have an opportunity at that time, 25 days from mailing, to apply for homestead and or any other exemptions that you may be entitled to. If you file after that date, I'm not sure exactly what the date is this year. It may be September 12th. I believe the mailing is around August 18th, or in and around those dates. Once September 12th passed, there is no way we can approve an exemption for 2025. So this, again, a very important document that you should pay attention to, although I'll go back to it for a second. It says right at the top, this is not a bill, do not pay. As soon as people say that, they throw it in the garbage. That is not something you should do. It is very important to read this because it has your new value, and you have an opportunity to contest your value during that time of the 25 days, or call us and maybe get additional exemptions. So please pay attention to it. The most important document you will receive from our office, and it's also available on our website. And this is showing you where to find it. You put in your address, go to the quick pick tools, trim notice, and the trim notice pulls right up. If you thought you should have received it in the mail and didn't, you can also go to our website and print a copy or look at a copy online. Along with the trim notice is an informational supplement that gives you all kinds of information about your values. And again, and it also tells you if you believe you qualified for homestead, and that homestead exemption does not appear on that trim notice, that means you may have not applied even though you thought you did, and you still have 25 days to do so at that point in time. So we want everybody to get the exemptions they're entitled to under the law. So this is like a last reminder to please apply if you have not yet. Save our homes. This is the most valuable discount, so to speak, that you have with regard to your taxes. 1992, there was a constitutional amendment proposed by the Lee County property appraiser that said that was back during a time where prices in Florida were skyrocketing and homeowners were being taxed out of their homes because there was no cap on the value of your home. So again, it was a period of high inflation and high property value increases. So they instituted the Save Our Homes cap, which limits the assessed value of your home once you've established homestead to a maximum of 3%. It's actually 3% or CPI, whichever is less. So the maximum your assessed value can go up once you've established homestead is 3%. I will tell you that in the last 10 years, because of the rise in real estate values in our county and across the state of Florida, we've had a compounded 10% increase annually in property values. And homesteaders have only gone up by 3% max every year. So they have now established a very large Save Our Homes cap that they're not paying taxes on. Now, when they do sell the property, the new owner, it goes to market value, and the new owner will face a much higher tax bill. And I'll have an example of that later on in the presentation. The difference between your market value and your assessed value is known as the Save Our Homes benefit. So look at CPI for the last 11 years. Only recently has CPI, because as we all know, inflation has been high in our country. Only recently have we been above the 3% cap. But look at 21 and earlier, the cap was 0.8, 0.7, 2.1, while market values were going up 8, 9, 10%. You were only going up a little bit in value for tax purposes. So, and there is also the non-homestead cap. If you are not homesteaded, your property is limited to you can only go up by 10% if there's a rise in market value. Greater than that, you only go up by 10. And we have about a third of our homes here in Pinellas County are not homesteaded. They're vacation homes, rental properties, it's vacant land, etc. And again, all caps reset on January 1 of the tax year after a transfer of the property. A transfer could be a sale. A transfer could be you put a deed and gave it to your children. That will reset the cap if you are no longer the homesteader. So be careful when you execute a deed, and Alex will get into that later in the presentation about common missteps. So here's a quick example of how Save Our Homes work. All this shows is market value going up by 5% and assessed value going up the maximum 3%. And as that goes up over the years, you will see that in year 7, all of a sudden, the market value is 400,000, the assessed value is 358. There's that 44,000 or so you're not paying taxes on, because you have the homestead, which comes off the assessed value to get the taxable value. Excuse me. The difference between the two is the Save Our Homes benefit. And that will appear on your trim notice. You will see that. You can see that on our website as well for the past years, what that benefit is. But let's say in year 7, that property sells, and that sells for $500,000. Well, what happens the year after purchase? Goes to market value. So that new owner who may have seen that taxes on this home that they bought were the last 4 or 5 years, $5,500, $6,000. All of a sudden, the year after their purchase, they're paying $9,000. That's state law. When a property changes hands or sells, it goes to market value. You don't get to inherit somebody else's cap. And here's a great example of, it's a very shocking example. These are 2 homes in the same neighborhood, same size, same lot size, same year built. The woman on the right has owned her property and homesteaded it since 1993. Her taxes annually in 2024, because of that Save Our Homes cap, are only $810. The house on the left was bought in 2020, went to market value. They're paying almost $5,000. Big disparity between very similar homes, but the benefit, this shows the benefit of the Save Our Homes cap over a period of 30 plus years. And then some of them are very dramatic. And so if that house on the right sells in 2025, guess what? Their taxes are probably going to be more than the one on the left. Let's say it sells for $450,000. Okay, their taxes are going to be closer to $8,000, and now they'll be paying more taxes than the house on the left. Is it fair? That's tough to decide, but that's the law. Non-homestead cap. Again, this was a constitutional amendment approved by the voters. What was happening to non-homestead properties, including commercial properties, restaurants, motels, strip centers were rising of the period of 2001 to 2006, 2007 at a rapid rate, and they were getting priced out of even being able to operate their properties. So they put a 10% cap. So this applies to all properties that do not have a homestead exemption, such as second homes, rental homes, commercial vacation homes, vacant land. And it applies to all millages, all the different millage rates on your tax bill except school. Another example of where the legislature made a change to help property owners pay less taxes, but they didn't want school taxes affected by that. So you're still paying school taxes, which could represent upwards of a third or more of your tax bill on the full market value, but you're only paying the other millages at that 10% cap. Again, the cap remains year over year unless there's an ownership change or if you apply for homestead. Let's say you decide to move to Florida. You've had this vacation property for a long time. The first January 1, you qualify for homestead, your property goes right to market value. So, and there are some instances where you have such a large cap, it may not behoove you to file for homestead, but we will help you through that. If you do file and we see that you may be better off still having the non-homestead, we will let you know and you can make that decision whether you want to homestead the property or not. Understanding the recapture rule. So all these years, in the last 10, everybody's assessed value has been going up at a very small rate. Let's say years 1, 2, 3, and 1, 2, and 3, where the market value is skyrocketing, right? Well, there will come a point where the market value starts going back down. Okay, but if the market value goes down, you'll see in year 4 and 5, the assessed value is still going up by CPI. So you may say, well, you're charging me more taxes when the value of my home is going down. Well, you weren't charged any taxes when the market value was on the way up. You were only going up by CPI. So there may come a time where you see your Save Our Homes benefit decrease, okay? And I have an example coming up here shortly. That is called recapture, where you're still going up for tax purposes by CPI, but your market value is coming down. So declining market, you'll see, and then assessed value meets just value. That's where they ride together. Assessed value can never be greater than market value. Year 6, and then year 7 and 8, it starts to rise again, and you save from the benefit of that CPI increase. So you may have a lot of questions related to those of you who had storm damage in 2024. Okay, how is this going to affect my 2025 taxes? The answer simply is it may not. Okay, because here's an example. This is a real life example of a home that was damaged in storm damage. They had a $330,000 Save Our Homes cap. The difference between market and assessed. This is a dramatic example, but there are a lot of homes where Homestead is established in the 90s who have a huge cap. So they're only paying taxes on $117,000 of value after the homestead exemption, only $67,000. So what's going to happen in 2025? The building value will decrease because it was damaged by the hurricane. But the building value is less than the overall deferred amount of $330,000. So in effect, what's going to happen is your assessed value is still going to go up, more than likely. So you're still going to be up by the 2.9%, and you'll lose some of that Save Our Homes benefit, that deferred. Portability. Another concept that was very well thought out by the Florida legislature back in 2008. What was happening is in 2001, 2000 to 2005, 6, property values were skyrocketing, similar to what they had done in the last 10 years here. But Floridians who had been longtime homesteaders taking advantage of that Save Our Homes benefit were priced out of moving out of that home and buying a new one, because when you buy a new home, it goes to market value. So they developed this concept of portability, whereby if you have that Save Our Homes benefit on your current home, you can take it with you if you homestead another property in the state of Florida. Anywhere in the state. It doesn't have to be Pinellas to Pinellas. So that difference on that home I just showed of $330,000, they can take that with them to the next home to reduce their taxes, because typically when you buy a new home, just market value equals assessed value. In this case, it's just market value less your portability will equal your assessed value on that new home. So it spurred transactions for people wanting to downsize, upsize, whatever. Now, there are limitations, which I'll go into. One is you have 3 tax years in order to do that benefit. If you sell in 2024, for instance, if you sold, you have 3 January 1s can pass before you have to establish homestead. So if you sell in 24, January 24 is 1, 25 is 2, 26 is 3. You must establish homestead by 1/1/27 in order to save that portability. So are you moving laterally? Are you upsizing? Or are you downsizing? So you can, with a new just value is greater than previous just value. Now the new just value of the new home you buy is the January 1 after you buy it, compared to previous just value of the home you sold is the January 1 in the year you sold it, not your sales price, the value that we had on your property. So if new is greater than old, you get the full benefit of the portability you had on the old, subject to a maximum of $500,000. That is specifically in the statute. Now, if you downsize, if new is less, you get a relative percentage. Let's say new was 400,000, old was 500,000, you're 80%, you get 80% of that Save Our Homes benefit from the previous home. Again, limited by the 500,000 max. And we have a tax estimator on our website that can do that, all that for you. If you're looking for, what will my taxes be on my new home? It handles portability as well. Previously, prior to 2021, you only had 2 January 1s to transfer that Save Our Homes benefit. Mr. Twitty championed legislation and put it before the voters. And in 21, the voters voted in, it required a 60% vote to extend that 1 more year. Because some people were selling in December. Let's say you just sold in December of 23. 1/1 in the old rule, 1/1/23 was 1 January 1, 1/1/24, a few days later after your sale was 2 January 1s. You had less than 13 months to establish, to move that portability. And some people were losing their portability because their new home was under construction, their condo was under construction, and it didn't get completed. And they lost their portability. So this, in the spirit of the law was to give you 2 years, but if you sold at the end of a year, you really had less, only 13 months. So the voters added 1 more year. So now the maximum time that you could have if you sell late in the year is a little over 2 years instead of 1 year. Portability after storm damage. We're getting a lot of questions for that now. People who lived in a storm damaged home, obviously their home's going to be valued less in 2025 than it was in 24. And the example I gave previously, you're going to lose some of that Save Our Homes benefit. But there is a provision in the statute where you sell your home in 25 with Homestead on it, and the previous year your home was damaged by a hurricane or storm, you can take the portability from 2024. This is a huge provision in the statute to help people in this regard. So typically the portability is from your last homesteaded year, okay? So if you were homesteaded in 25, we take the port from 25. But there is a storm damage provision in this statute that allows you to take more than likely the larger amount from 2024. So so if any of you are contemplating selling your storm damage home in 25, rest assured your portability can come from 24. Portability and divorce. A portability is a very large asset that a lot of divorcing couples don't consider when they are thinking about divorce. Let's say a home has $800,000 of value that they're not getting taxed on. Okay, who gets that in the divorce? Okay, the husband or wife who stays in the marital home, or the one who moves out and applies for homestead on another home. Remember, a married couple can't have two, but now that they're divorced, they can. Well, they've lived in this home for a long time. Okay, they have to come to a resolution as to who gets that portability. Unfortunately, they don't always do that in the divorce decree. They don't always consider it. But, and let me go back here, but there is a form, okay, it's the DR 501TS, which the couple can fill out. We prefer they fill it out before the divorce is finalized. That's what the statutes require. But our office will allow them to fill that out after the divorce, or maybe they decide each of us gets half. And then at that 800,000 portability, 400 can stay on the marital home and 400 can transfer with the spouse that moved out of the home. And now I will turn it over to Mr. Alex Luca, our Director of Exemptions, to take you through the rest of the presentation.
All right. Thank you, Kevin. So I'm going to go through pretty much all the other exemptions. The homestead and the Save Our Homes cap and portability, they're massive benefits, but there are other exemptions available. And these other exemptions primarily relate to seniors, veterans and first responders, and disabled people. So if you fit any of those criteria, it is important to look into this. And there's also a widower exemption as well. This is a list here, and we're going to go through each one and what it takes to qualify for them and what the benefit of each of the exemption is. So first, you've got your $5,000 personal exemptions. Now, that's not $5,000 off the taxes. That's off of your assessed value, which equates to anywhere between $80 and $100 after taxes per year. There are three of these, which is the widower, the disability, which means you're 100% total and permanently disabled, but you're not wheelchair bound. There is an income limited exemption for wheelchair bound disabled folks that exempts them fully from taxes that we'll get into in a moment. There are also a blind person exemption that if you are certified by the Division of Blind Services, Social Security Association, or Veteran Affairs, you can then also get this exemption. Now, these exemptions can stack on multiple properties. They are not bound to your primary residence, but you can only have up to three of them, so 15,000 total. So if you're a widower and you own three properties, you can have the widower exemption on all three properties. Now, if you're a widower and you're blind, then you can only have three total. So if you own two properties, you could have the widows and the blind on one and the widows on the other. The maximum is the 15,000 on that. These exemptions were increased. Previously, it was only $500 off of your assessed value, which was maybe $15 to $20 off your taxes. In 2023, the law went into effect to increase this, making it a little bit higher. So this is the exemption for totally and permanently disabled people. This is for paraplegic, hemiplegic, or other TMP person. And so for this one, it is bound to your permanent residence. And the reasoning behind this is it is a full tax exemption if you qualify for this one. And every year it's income bound. So every year there's a new income limit. For 2025, the income limit is $36,745. In order to qualify for this exemption, you must provide our office a statement of your gross income and any supporting documentation, and we will ask for this information annually. You also have to have a certificate from 2 licensed Florida physicians or the VA stating that it is a total and permanent disability. So the low income senior exemption is another one. You have to have homestead and you have to have been the owner of the property while you were 65 as of January 1. So this one has the the income restriction on it. For 2025, it's 37,694, and you must be in a taxing district that offers this exemption because it is a local option. So each taxing district will adopt this exemption, and we'll go into here. These are the taxing districts that have the low-income seniors exemption. And if you look here, you can see how much they each are. And this number can differ greatly because they can go up to 50,000 on the exemption. But also each taxing district has their own tax rates. So if you see in Bel Air, it has a very high amount because they're offering the full 50,000 and their millage rate is a little high, so you get 350. Yes. Unincorporated is there at the bottom right. That's unincorporated Pinellas County. And that one is 104. That's all right. So they actually increased their exemption this year. Previously, unincorporated Pinellas was 25,000. They upped it to 50,000. So now you're getting about 100 off of your taxes as opposed to 52. The next one we will go through is the low-income senior long-term residency exemption. This is only in 3 municipalities, St. Pete, North Reddington Beach, and Safety Harbor. It's another local option, but it exempts the amount of the assessed value if the just value in the year of application is less than 250,000. So what this means is when you apply for this exemption, you have to have resided on the property for 25 years or longer and be over 65 and meet that income limitation. And the just value of their property that same year has to be 250,000 or less. And so if you're at 251,000, fortunately, we can't give it to you. But it is a lot of criteria for this, but it is a good exemption if you do qualify for it. So, you've been hearing me say January 1 and Kevin talking about January 1 a lot during this presentation. That is because January 1st is kind of the golden date for property appraisal. It's called the reassessment date. When we're valuing your property or looking at whether you qualify for an exemption or not, January 1st is the snapshot date we're looking at. If you own a home on January 2nd, unfortunately, you wouldn't qualify for any exemptions as of for that tax year because we're required to look at January 1st for ownership for the tax roll and for valuing your home. So, you must permanently reside on the property as of January 1. You have to own it as of January 1. But for whether or not you're getting documentation towards the exemption, that's not as important. If you're still waiting on your Florida driver's license or vehicle registration, that can come after January 1st, so long as you were a resident, you were living here as of January 1. The application deadline for the homestead exemption is March 1st. That is the deadline. However, we do get the late file deadline, which I believe Kevin mentioned is September 12th this year. And that date's going to shift a little bit because the Florida law says when we mail out those truth in millage proposed tax notices, the date of the mailing, you have 25 days from the date of that mailing to late file for any exemptions that you may qualify for. You also get 25 days to appeal. And so if you believe that our value is too high, or if your exemption was denied for some reason and you believe you qualify, you can also appeal within 25 days to another administrative board called the Value Adjustment Board. And then for VA disabilities effective after January 1, the application made is processed for the following year. So we're going to get into your veterans and first responders exemptions here. If you have a service-connected disability of 10% or greater, you're going to get a 5,000 exemption. This does stack with those other ones as well, up to 3. You have a total and permanent service-connected disability, which means you're at 100% or total and permanent, and that will give you a 100% exemption, and there is no income requirement for this one. For veterans 65 and over with a combat disability, whatever your ratings letter says, you're going to have your taxes reduced by that percentage. If you're confined to a wheelchair requiring special adaptive housing, you're 100% exempt. And for Florida first responders, you can be 100% exempt if you have a TMP disability. Now, For the first responders, there is an important provision related to cardiac events that do require some extra documentation. So just keep that in mind if you are applying for that exemption. So what we're looking for when you're applying for your veterans exemption, we're going to want your summary of benefits, ratings, decision letter, and we want to know the effective date of the disability because that January 1 date is very important to us. We need to know when your disability's effective date was. So your DD 214 stating that you were honorably discharged, which is also a requirement. And if you are a surviving spouse of a veteran who's going to continue to claim the deceased veterans exemption, then you also need to have the death certificate and marriage certificate or something proving that you guys were married if it's not on the death certificate. And also down here at the bottom is the Pinellas County Veterans Service Office. They work very closely with us, for these exemptions, and so you can always call them for additional information, and they will work directly with us to make sure you get the exemptions that you are entitled to as a veteran. Deployed service members, this is another one. So it reduces your taxes by the number of days deployed outside of the United States. To qualify, you must have the homestead exemption currently, and you have to have deployment must be in operations designated by the Florida legislator. So on that, I don't know them off the top of my head, but they do have a list in the Florida statutes of what each operation is that would qualify for this. And also active duty military or reserves includes the Coast Guard and National Guard as well. And it's not mentioned on here actually, but there is another benefit for deployed members. So you cannot rent your homestead property, but if you are active U.S. military and deployed, you are exempted from the rental rules related to the homestead exemption. But we would need proof that you are deployed. So this is the transfer of tax exemption for veterans and surviving spouses. So now there's a new rule that if you previously had the total and permanent tax exemption and you bought a property mid-year, you would be originally, the way the law worked is you would be on the hook for the seller's taxes for the remainder of the year. Because when you buy after January 1, we look at the ownership as of January 1. Well, in July 1st, 2020, the legislator said no, that shouldn't work that way. What we're going to do is if a veteran or their surviving spouse buys mid-year, we're going to do a prorated refund for the remainder of the year if they buy between January 2 and November 1st, I believe. Yeah, November 1st. Then in 2024, they updated this law again to allow for that refund to still be issued as long as they qualified as of January 1, even if they did not claim that exemption on another property previously, which was the requirement in the original bill from 2020. It's a little complicated, but if you have questions about it, please just give us a call and we can walk you through it. So now we're going to get into the common missteps related to exemptions. And a lot of this has to do with transfers of ownership, your cap reset issues. So Kevin alluded to this, when you apply for homestead on a property that didn't have homestead previously, your cap resets. And vice versa. If you lose your homestead or you no longer live there or don't qualify, you are also going to have a reset to the market value. You don't get a 10% cap that runs behind the homestead. You get one or the other. And anytime it changes statuses, it resets to the full market value. So a big issue we run into is new home buyers. They will be looking at the prior year's taxes, and you may have somebody like the example we had up there they've owned that property since 1993, and they pay $800 in taxes. So when you look at it and you look at what the taxes are, you see $800. And when you buy it the following tax year, it goes to market value, and the taxes can triple. Sometimes we've seen them go up to 10 times what the taxes were because there was just a very large homestead cap. Another issue is when homeowners transfer their property into an LLC. This is a very common thing to do with rental properties to protect your liability. However, an LLC is considered separate and distinct from its members. So you may be the sole owner of that LLC. It may be a pass-through and you pay income taxes directly on anything from that LLC. However, for real property purposes, an LLC is treated separately. So when you put it into an LLC or remove it from an LLC, your cap is going to be reassessed to the market value. And it can hurt if you don't catch it in time, because if ownership is put back in place that same tax year prior to the next January 1, we don't treat that as a transfer mid-year. We're looking at January 1 to January 1, then the cap won't reassess in that situation. So for homestead removal, this is, I guess, I'm not sure if there's another slide on that. So this is the sneaky seller, is what we call it, a little bit jokingly. But what it really is if you buy a home and you're under the impression that the seller's homestead exemption will remain on the property when you purchased it. However, if the seller owned another home as of January 1 of that same year they sold you the home, legally they can transfer their homestead to the property that they owned, their other home, and remove it from the home that you bought. And what this can result in is you having an understanding that the taxes were going to be lower, but the seller transferred their homestead to their other home they own. And there's nothing we can do about it if they do it prior to the deadline to apply, which is March 1st. And it's difficult, but it is something that they are legally allowed to do. If you own a home as of January 1, you can make a homestead application on it, and we're required to approve it so long as they qualify. And so if you want to request the homestead be removed from our office as well, this is what we tell new buyers. If they buy before March 1st, check our website regularly, because if the seller is removing the homestead, it will reflect on our website within 2 to 3 days. So renting homesteaded property. This is another big one. So you cannot rent a property that has homestead for more than 30 days in 2 consecutive years. If you do, it's no longer considered your permanent residence and you will lose your homestead. And if this goes on longer and we don't catch it in time, when we do find out about the rental, we can remove prior years that it was rented, and then you are liened a 50% penalty and 15% interest on that. And so how this 30-day and 2 consecutive years works is if you rent it 31 days in 2024 and 31 days in 2025, your homestead is removed for 2025. But if you rented it for 180 days in 2024 and 10 days in 2025, you could still keep the homestead. It's 2 consecutive years. But also, we look at the January 1st date too. So if it's rented through January 1st, you are no longer occupying it as of January 1st, you may not be able to qualify for the homestead. Changes to the deed. This is another big issue that we run into. A lot of do-it-yourself deeds that come through for people trying to estate plan. And if the tenancy, which is, the tenancy means the type of ownership, the tenancy is not done properly, you can remove a portion of your homestead or a portion of whatever other exemptions you may have, or all of it, depending on how it's done. And some examples are, adding a name or adding it to a trust or creating a life estate. And if they're not done properly, you can lose those exemptions. And this is why we always say, if you are making those changes, it doesn't hurt to just pick up the phone and ask us. If I'm going to do this, or I'm going to add my child on in this way with my deed, call us and ask, how will that affect my exemptions? And we are glad to explain it to you. And chances are it may not, but it's better to have that up front than find out on the next year's tax bill that you lost half your exemption. Yes. Mm-hmm.
People live, only one person has filed for home.
Ah, yes. So this is a common misstep too that we do see. So joint tenants with rights of survivorship is a form of ownership where if one person passes away, the other one immediately gets 100% ownership. And while they're both alive, they're both considered to have 100% ownership. Uh, and also, at any time, either one can have the homestead exemption or both can have the homestead exemption. In the situation Kevin was asking about, you have, let's just say, mother-daughter, they have survivorship rights on the property. Only mother has the homestead exemption. Daughter has never applied for homestead exemption. She may live there, she may not, but she never applied. When mother passes away, the daughter will instantly have 100% ownership of the property. However, because the homestead was her mother's and the daughter had never applied, the property is going to be taxed at the market value the year after her mother passed away. This is very common because people think, well, we're both on the deed and my mother had a homestead exemption. I just assumed I did too. The homestead exemption is tied to you personally or a married family unit, is what it's called, or marital couple. So if you have not applied for that exemption and you own the property too, Florida law says if you haven't made the initial application, you have waived your right for that exemption for that particular year. And so it's very important to apply if you do live there and you're not claiming an exemption elsewhere. If they're not on the deed, then they can't apply. And in that situation, unfortunately, it's going to reset no matter what because it is tied to the person. Mhm. Yeah. And she's not on the deed. Yeah. So that then then there's if you were to pass away, it would go to the market value. And now we'll move on to kind of some of our resources available right now. I know this is kind of the big one right now on our homepage there. There's our After the Storm FAQ. We highly recommend anybody that was affected by the storm take a look at that. Go on our YouTube and watch our storm damage presentation where we had the floodplain manager Lisa Foster there as well. It's a wonderful amount of information. And also on this link, you can apply for your DR 465 refund on taxes as well and get information on anything else you need related to your property taxes and storm recovery. And this is what the page looks right here. First one is your tax refund. Then there's a little bit about the how do you find your 50% or 49% letter on our website and some other information as well. Moving on, we have a buyer and seller fact sheet as well. I believe we have some of these at our office as well. If you're looking into buying or selling, this is just going to be some information related to your taxes that you might want to take a look at ahead of time. And it also is going to, direct you to our tax estimator on our website, which is wonderful for getting an idea of if you're going to buy, what your taxes are going to be. And so I believe it's every month, we do have one of these educational series. So, stay tuned for the next one that'll be coming up. And I really appreciate everyone for joining us today. If you have any questions, please, we'll be here to answer them. Put them in the chat, or for the folks that are attending here as well, we'll be around to answer any questions you may have. And then, of course, we always encourage everybody, follow us on Facebook and YouTube. There's a lot of resources that we put out for everybody. Thank you. And the last one, there was one more here. So Property Fraud Alert Service. This is actually an amazing service that's completely free, and it's administered by the clerk of the court and controller's office. What this is it's a service similar to your other fraud reporting services, but this one is completely free. What you do is you put in your name and your information, and the clerk will notify you if anything is recorded in their records that has your name on it. So you can keep an eye out. Let's say you're buying a home, your deed should be recorded. You should get an alert saying there's an instrument recorded in your name. But also it'll alert you if something's recorded in your name and you didn't know about it. So then you can look at it and take the appropriate action that needs to be done. Very, very useful service. I highly recommend everybody sign up for this. So thank you.